if you'd like. Good afternoon, everyone, and thank you for joining us today. I'm Robin Albert. I'm the Marketing and Training Manager for VMEC, which is the Vermont Manufacturing Extension Center. And welcome to Regulatory Compliance Deep Dive. Hopefully on your screen, you see the opening slide. If you don't, come off mute after I'm done with the intros and before we start the presentation, because we want you to get as much out of this as possible. We appreciate your time and interest this afternoon in this valuable webinar topic, which is a co-sponsored webinar between VMEC and the Vermont Law and Graduate School. The webinar will be recorded. We are recording right now. We'll take it off recording when we start the Q&A portion at the end of the session, so you can openly ask your questions that might be particular to you and your organization. And without further ado, I would like to introduce our three presenters for this afternoon. First off is Jeannette Eicks. She is an adjunct faculty member at Vermont Law and Graduate School. She teaches eLawyering, data security and breach, emerging technology and the law, and AI and the law. Second up on our docket is Nicole Killoran, who graduated from Vermont Law School in 2012. After graduation, she practiced with a firm in litigation, land use, Act 250, landlord-tenant, property, and bankruptcy law. Today, she directs the Small Business Law Clinic and the Vermont Small Business Law Center at the Vermont Law and Graduate School. And last but not least, Christina Williams. Christina is a May 2026 JD candidate at Vermont Law and Graduate School. She is an advanced student clinician of the Small Business Clinic and is a former EHS compliance specialist and project manager. I'm going to turn it over to Jeannie or Nicole. Thank you for being here and enjoy the next hour with us.
So I'm going to actually give you a minute, Nicole, to introduce the Small Business Law Center, if you would, and take a minute to talk about what it is we do and we offer before we get started.
Sure. So I think we might have a slide on this at the end, but we provide legal education and access to legal services for small businesses, and that includes nonprofits. The scope of our services is mostly educational. We provide information to businesses and business owners to help them understand the legal questions that they have. We also do public content like this. We love to work with our partners like VMEC to target particular topics that are of interest to a group of people or to the public. We do that as well. So that's our educational program. We also run, for right now, we run a referral program. We have a network of attorneys that we can send people to. We can place a business with an attorney for services, and then we can pay, at least for the next few months, up to 10 hours of services that business receives from the attorney. So we pair these things, and we are hopefully getting small businesses the information they need and getting them to an attorney to get the services that they need. We can come back to that if anybody's interested in discussing at the end, but that's the context that we're approaching this from, because we have found that putting information in the hands of businesses makes them more successful, and understanding the basic legal concepts that one needs to be successful and to avoid risk and problems in the future. That's why we do what we do. So it's part of why we're here.
Thanks, Nicole. So without further ado, today we are going to talk to you about regulatory compliance. We're going to talk about what regulations are, how they impact your business, and we're going to give you some examples of different regulations. We're going to talk about how those regulations, again, may impact you and your business. A little bit about the difference between permitting, which is sort of the how you're doing something, and then licensing, which is who is doing it. We'll talk to you about data privacy, food, children's products, clothing labeling, a little bit about the ADA, which is the Americans with Disabilities Act. And then we'll talk also in there about OSHA and VOSHA, which is safety in regards to what it is that you do in your business. Next slide, please. So what is regulatory compliance, right? This is really fancy legal language. And we don't often talk about what it looks like and the impact it has on your business. So when you're thinking about regulatory compliance and what that is, what you're really talking about is, do I need a permit for the activity I'm doing and how I'm doing it? Do I need a permit for the project I'm taking on, for the event I'm holding, right? All of these things can take a permit. right? Should I talk to zoning? Can I put up a building here? Can I do my different manufacturing functions within this space, right? Sometimes spaces are zoned for certain things, and other times they're just zoned residential, and you can't do any of those things there. So you really have to think about that. And then, should I talk to my neighbors in advance? How does this roll out? Do I apply for the permit first and then tell my neighbors I have the permit, or do I talk to my neighbors and say, hey, we're thinking about doing these sorts of things. Would you have any objections? What would they be? And you have a conversation with your neighbors, right? And sometimes that's about being a good neighbor and helping really get ahead of that permitting process and having that early conversation. And then, the final question is, can I work out of my home? As I said before, sometimes areas are just zoned residential and you can't even work out of your home. Home-based businesses is not allowed. So that too is something to think about and falls under this regulatory compliance set of rules that we have to work with it. And then some sort of areas where you're going to see regulation and your business is arguably already in a situation where you have to comply with those regulations, right? You've got all the different regulations around taxes, around employment. You've got customer data privacy. If you're doing manufacturing that involves something that has an inherent dangerous aspect to it, I understand there was somebody who does glass manufacturing or glass blowing on this call. Obviously, there are some inherent challenges and dangers and safety precautions that need to be taken, and those are often regulated and require permitting to undertake. So, all of these sorts of things have regulations that force businesses to comply and behave in a certain predictable way so that the rest of society can relate to how it is that you are interacting and engaging with the world. And then, businesses, they get out there in the world and they're surprised because they don't know that this thing I'm doing is actually regulated, right? I mean, I know the first time that I encountered hey, you can't do a home-based business zoning regulation, I was shocked. I said, what do you mean I can't sit at my computer and run my e-commerce website? It seemed kind of crazy to me, right? But there are certainly zoning regulations that limit the kind of things you can do and how you do them in your home. All right. And then obviously, if you're selling directly to consumers, you've got some labeling requirements, you've got some delivery expectations, you've got all of these sorts of things. What can you ship, when you can ship it, how you have to label it when you ship it, how you have to label it for consumer safety, how you label your food products, what you can say, when is it organic, when is it not organic. Can you say, hey, we really don't use any kind of chemicals on this? And is that confusing to the public, right? Um, what does what does my website need to have on it to be ADA compliant and accessible for customers? There's certainly a bit of attention being paid to that right now, and some what we might construe as aggressive lawsuits coming towards businesses about ADA compliance for websites. Next slide, please. So we throw this out here because this is often what we think of internally and what businesses cringe over, right? This is what's in your head and you go, oh my goodness, I'm going to have to do that. And we often talk about a threshold, and businesses reach that threshold and they think, ugh, I can't get over that threshold. So first and foremost, right, the agencies in the state of Vermont, most of them have good websites. Most of them talk about their regulations and the regulations and rules they're in charge of applying to small businesses. And they have how-tos and help out there, right? This isn't something where you can't reach out, pick up a phone, and call an agency and talk to them, right? And in fact, I would encourage you to do that with both your town clerk and your agency. It's always a good first step. Now, If you're already into something up to your elbows and you go, oh, shoot, I should have been complying with something for the last 5 years, perhaps it's a good time to reach out to a lawyer. Um, but, but on the other hand, right, always be transparent, always be direct, always be honest, open, and truthful about all of those situations. And this regulation spaghetti will be streamlined and it will become easier for you. Next slide, please. So, as I was talking before, most of these agencies that are in charge of enforcing these rules are also the agencies promulgating these rules, right? And so the way this works, sort of in a nutshell, is your legislators, they create laws, the governor signs them, and they hand them to agencies to create rules that basically work to enforce that law, right? And work to provide the details for that law, because the legislature doesn't often get down into the weeds on these things, right? And so you have all of these different agencies, both federal and state, who are charged with, you know, executing these rules and creating them to enforce our laws and to carry out our laws. So we have from a federal perspective, we have Department of Veteran Affairs, Center for Disease Control, National Labor Relations Board, FINRA, which is a Financial Industry Regulatory Authority, EPA, Securities and Exchange Commission. Some of these should be sounding pretty familiar to you, the Food and Drug Administration, right? We often have a lot of secretaries interviewed on pick your Sunday morning news show, right? And they're talking about the most recent report or regulations coming out of their agency. However, quietly, Vermont agencies are doing some of those same steps, and they mirror in some ways what the federal government is doing just on a state level. And so it's good to know that those agencies are at the state house, or not at the state house, they're in state government. And these are the places where you would want to reach out, go to vermont.gov, find an agency that you think might sort of have that sorry, there was somebody walked into the office. So they might have control over that area that you have questions about, and start there. If you don't get to the right place the first time at the state of Vermont, they're terribly helpful folks. They will refer you on to the agency that does have that rule in their purview. Okay. Next slide, please. So talked a little bit about the rulemaking process. This is a little more in the weeds, right? When the law is created at the legislature, it gets signed by the governor, and then it goes to that agency. And the agency will create rules, as I said, to create depth to that law and to implement the law. The first thing that happens is there's a notice of proposed rulemaking. This is really critical for businesses to be aware of, because following on this notice of proposed rulemaking is a public comment period. So if you're a business and you're going to be infringed in some way or impeded from doing your business because of these rules, this is your opportunity to make comments about it and say, hey, wait a minute, when you say that, it's doing the following. Did you mean to do that? Right? And sometimes the agency is like, oh, well, wait a minute. That isn't the spirit of this law. That's not why we were doing this. We need to reconsider the rule and the potential impact, right? And they'll go through an iterative process that really allows them to tweak that, so it's really having the effect they want it to have and not some unintended consequence on a business. So make sure you keep that dialogue open. This is your government. Talk to them, right? And then once this review and analysis has happened in this iterative process, the agency will issue a final rule, and then there's implementation and enforcement. So if you're paying attention and this is an area of interest to you, whatever the area is, you're not going to get caught unaware of new rules and laws, because they're out there, they're in the public eye and the public sphere, and your government is asking you for feedback and comment. So take that time to do it. Next slide, please. So permitting. What is permitting? Permitting is the main tool for meeting statutory mission and ensuring compliance, right? This is how that rule is sort of turned over to the businesses for them to act in a way that has been shaped by the legislature. It allows society to carry out its policies, right? And its idea of what good society looks like, right? And that's coming to you in the form of these rules and these permitting requirements that will force your behavior into your execution of the how into a certain set of guidelines, right? There's a lot of different types of permitting out there. There's zoning, there's environment, there's operational, special use, discharge, safety, food safety, there's worker safety. I'm forgetting some. So, chime in. There are lots and lots of different kinds of permits out there, right? And the process generally is there'll be an application period or an application process, pardon me, where the criteria and the rules set out by the agency. Sometimes it's a form on their website that you complete. Sometimes it's a little more complicated and it involves an inspection or it involves some kind of iterative process. There can be a lot of different pieces to a permitting process, or it can be a straightforward, just fill in this form and you've got it, right? So you go through, you look at the rules that are set out by the agency, and you see what you need to do to comply with that particular set of rules. Now, the permit can be approved or denied, right? And people don't think of that, right? They think, hey, I'm just going to apply to, and let's use zoning and signage because that's something we see all the time, right? So I want to put a sign out on the edge of the road and I want it to be 40 foot by 40 foot. You can imagine that perhaps in Vermont, that's not going to go over so well, right? And so your permit is going to get rejected, right? Your permit application is going to be rejected if you have this because you're not following the rules and the criterion set by the agency for what signs have to do, right? And so they'll be after you've applied for this permit, you'll see the public saying, "Oh no, not in my backyard. We're not having a 40 foot by 40 foot sign." And so what that will do is inform the agency that, hey, no, these folks didn't go out. Remember before when we said you should talk to your neighbors? Yeah, this is part of the process because when you go through an application for a permit, if you talk to your neighbors and you've slowly helped them adjust to the idea of whatever you're doing, you're going to get less pushback in a public comment period for a permit, and it's going to move more smoothly. And you're less likely to be denied if everybody's on the same page, right? As long as you complied with the rules and nobody's raising a stink about it, you're much more likely to get the permit, right? But if your permit is denied, there is an appeal process, and it's an administrative appeal process. And then if you do it anyway, say, I've got to have this 40 foot by 40 foot sign. I don't care what you guys think, I'm doing it anyway. Then you get to learn about enforcement, right? And fines. And the government coming in and saying, I don't care if you spent $100,000 on that sign, take it down now. Right. All right, next slide, please. So agencies enforcement process, these are powers granted by statutes, right? And so agencies can come in and they can fine and they can say take it down and they can order you to do these things, and it can turn into civil litigation. And that 40 by 40 sign that was $100,000 to put up just cost you $250,000 in noncompliance and other fees related to the fact that you put it up anyway, right? So it's really important to think about these things. And then in some extreme cases, there can even be criminal charges involved in permitting violations, right? So think about this from an environmental perspective and somebody dumping off hazardous waste into the Winooski River, right? That obviously can have some criminal repercussions for the individuals that did this if there is an argument to be made that they knowingly inflicted harm on their fellow citizens, right? So lots and lots of potential ramifications for people who do not get their permits, do not file things appropriately, and do not comply, right? And then the final piece here, reputational damage, right? You made your neighbors mad. And when I said raising a stink before, we have all lived, if you're in Vermont, in a small town or an environment that felt small townish, and everybody knows what's happening and everybody's keeping tabs on what's happening. And next thing you know, you're doing half the business you were doing before. Right. So real world impacts too around reputational damage. Next slide, please. So what can I do? So for a lot of small businesses, having a compliance officer, that's a big reach. However, if you're a medium-sized business, having a compliance officer or at least someone you pay part-time to do this for you, really a great idea. Have a compliance officer. Um, if you can't have a compliance officer, go to an attorney. Have a conversation about what are the kinds of regulations that could potentially be impacting me that I'm unaware of. It's worth the hour of your time to pay an attorney to do that. It's cheap insurance. It really is. If we think about all the money we put into general liability insurance and then what we would have paid for an hour of an attorney's time to tell us which permits we should be applying for and which licenses we have failed to get, it's a much better financial trade-off to pay the attorney for those things and to become compliant. Other things you can do, sometimes you comply, but it requires that your employees also follow a certain set of steps, right? And so when that's the case, you have to create awareness in your company and you have to train your employees on their duties to comply with a certain safety statute, for example, or a safety rule, for example, right? And then there's policies and procedures around that, right? You want to set up certain ways of doing things, a certain process that must be followed. When you do this kind of cooking, you must make sure that you wipe off the counter and you wipe it off and sanitize it with bleach before you start the next part of your process, right? Whatever those processes are to meet your obligations, either under a permit, under licensing, or under some other rule, you should be doing those things. All right. Audits and controls. This is the place at which you don't just say you're doing it, you check to make sure you did it. Right. Because it's great to train people, it's great to raise awareness. If nobody is checking on them, they're saying, yeah, whatever in the training instead of I'm being held accountable. And so audits and controls are in place to ensure accountability internally before it becomes an issue externally in the form of fines or other kinds of impacts. Managing your risk, right? This is about saying, if I do this, it's the old Ben Franklin saying, right? An ounce of prevention is worth a pound of cure, right? And so anytime you can manage the risk, anytime you can go in and say, if we do this up front, we won't have this exposure on the backside. It's very helpful to your business and it's going to move you towards profitability. Partnership and consultations. Partnerships and consultations. Always talk to others in the same area of business manufacturer you're in. What are they doing? What kinds of regulations are they complying with? That's some of your best conversations are going to happen with those in similar businesses to you. And you can talk about who they consulted with. Do they have a part-time compliance officer? Maybe you could all pool money together and get a compliance officer for 5 different manufacturers doing about the same type of manufacturing, right? Let's say you're microbreweries, right? Suddenly you've got a compliance officer that works for all 5 of you because you're all complying with exactly the same kinds of rules. Next slide, please. All right.
That's going to be me. I get to talk about land use and zoning. So we've already talked about this a little bit. This is my area of specialty or expertise, you could say. It's also the one that catches people up the most often. So Jeannie's already mentioned the possibility of having a requirement to have a home-based business permit. That's the one that we see the most often that applies to small businesses. I'm going to go through the process in general for land use and zoning in Vermont, because it is a good idea. Anybody who has a brick and mortar, anybody who has any sort of physical base to their business, they need to be aware of the fact that the town may have an opinion about what they're doing. In general, when it comes to figuring out what somebody can do with the property that they own or are renting, there will be, as Jeannie said, there's an application process. Often there will be a process of negotiating with the town in terms of dimensions of a project. If there's going to be a new build, what is the construction period going to look like? What are the protections going to be in that period? If it is, building out the inside of a building, similar concerns. If it is just switching the use from a previous business use to a new business use, there's still going to be a process with the town where they're going to have to examine the regulations that apply to this zone and to your kind of business. So it does take time. It's not something that is, business can just walk in and say, hey, I need this, and then they get it. There will be not just a negotiation with the town, but there will be a process potentially depending on the project that's being proposed. There may be a hearing that the public gets to attend. There may be opportunity for the public to participate, to comment on the permit that's being proposed. There may be multiple hearings depending on the complexity of the project. There will be a decision at the end of it from the town. Anybody who's proposing to get a permit from a town is going to get a decision. If they don't get a decision within 45 days, it's deemed to be approved. But town issues a decision, and that becomes, and we'll touch back on that later, because once the decision is reached, there's also another stage for any given project, which is waiting for neighbors to appeal. There is a difference in how certain projects are treated when it comes to getting a land use permit from the town. If it is the town splits its land use into, or land area into, different zones. There will be an industrial, maybe a commercial, maybe a mixed residential commercial. Each of these zones has different uses and purposes, and there are different things that can be done within each of those zones. So the things that can be done are the permitted uses. So say we got a commercial zone, probably most commercial uses will be allowed in that zone, but industrial uses would probably not be allowed in that zone. So permitted uses in a residential area will be a single family home. Those are almost always allowed. Those don't typically require permits. They are just something that might need a check with the town, but that otherwise there's no permit for that particular project. It's just something that is allowed within that zone. Conditional use, pardon me, is for stuff that you want to do with your property that's a little bit different than what the zone anticipates. So maybe a commercial use in a residential zone, or maybe a mild industrial project that's going to be operating out of a commercial or residential zone. Those are the sorts of things that trigger, usually under town rules, the requirement to have a little bit of a closer look. Conditional use is a process that a project can go through where the town says, okay, we're going to let you do this thing with your property, but we're going to put some conditions on it. We're going to put some rules that you have to follow on that permit. And the rules are usually to anticipate potential impacts from that property. So usually has something, the conditions on a permit might look something like, we want screening, we want shrubs to be put up, we want there to be this put in place so that there's drainage from this particular activity. We want these protections to be put in place, tree put here so the neighbor doesn't see you. Those sorts of things are worked out through the process and put into the permit that those conditions must be complied with in order for that person to continue to have the permit. When it comes to towns applying their rules, I will say they get a lot of discretion, and that just means that a lot of people's opinions come into the process for town permitting. This looks like asking for a town permit, the town saying, okay, well, we can allow that, but we don't really want to allow it this way. Okay, we'll deny it because we don't like it this way, or we'll deny it because it doesn't fit the character of the area, or maybe they'll grant a permit, but they'll put some sort of condition on there. What I'm trying to impress upon you is that there's the reason that we have to negotiate with the towns on these permits is because the towns get to really decide within pretty broad standard what they can and cannot allow. It's hard to overturn a decision to deny a permit from a town. It's a little easier to challenge one that has been granted. But they do have discretionary standards that they follow. That also means that if there's some sort of a rule in place for a project that you want to build in a town, and there's some resistance from the town, you can ask for a waiver. A waiver is a request to the town to say, okay, we have this rule, we're just going to not apply it to you here. Again, the town has a lot of discretion to decide what to apply and not apply. So that's discretionary standards and waiver. The last one there, I will point out, a variance is what somebody has to do with their property if they have no other way to get a permit for it from the town. That is where somebody goes to the town and says, maybe this used to be done on this property. Maybe there was a building here that used to have this function 10 years ago. It was discontinued, but I want to do it again. Or maybe this is a small lot and I want to put a shed on it and I don't have anywhere to put it except for this spot, and it doesn't fit under the rules. Variances are very hard to get. I just want to mention them because they are an option. If for some reason the town says, no, you can't do that with your property, there may be a possibility of saying, well, we want a variance from these rules. Last item there, we've mentioned appeals. This is the power of the neighbor in Vermont. The judges that hear these cases in court call this divorce court for neighbors, because often these zoning disputes are how neighbors air their concerns with the person who lives next door about the way that they're using their property, about the way that their fence is encroaching on their property, about the exhaust that's coming out of their pipes, whatever it is. Appeals are an appeal power is given to neighbors who participate in the town zoning process. They get to take it all the way up to the Supreme Court if they want to. Just be aware that neighbors have a lot of power. Jeannie already said, talk to your neighbors. Also talk to your zoning administrator. The zoning administrator has a lot of power in these decisions. Neighbors can slow things down. They can stop a project. They can make things very expensive. If there's any sort of property boundary issues, those really need to be addressed before zoning is approached. Those almost always get projects shut down or get complications with neighbors. The third bullet point under navigation tips, I mentioned septic because this is rife with issues in Vermont. We have properties that have old septic that need to be updated. We have properties that have septic on somebody else's property that they don't realize they have over there. This is an issue that stops and slows projects. So it's a good idea, especially working with an old project or an old property rather. If you're working with an old property, you're trying to get a zoning permit, make sure you're addressing the septic needs for that property and figuring that out first. If you have to get state level permits as well as town permits, I recommend you get the state permits first because that's usually a better process to iron out that process first. And then, of course, we have Act 250, which I'll touch on briefly. This is a big state level land use statute that everybody needs to really know about, but this applies only to certain properties. So most everybody's heard Act 250. This is how the state tells you what you can and cannot build at a large scale. The triggers for having Act 250 apply to your property and your project are the ones here at the top of the screen. If this is a town in Vermont that is what we call a regulated town, they have both zoning and subdivision rules that the town has enacted. That is called a 10-acre town. That means that in that town, if there is a proposal to do commercial development on a 10+ acre size lot, or if there's a proposal to subdivide at least 10 lots from one parcel in the same 5-mile radius, that triggers Act 250. That means that the state will require that the project, the business, go through a long process to examine the impacts of its project, of its proposal, on particular protected criteria for the state, usually environmental criteria. So 10-acre town, again, usually the trigger is for most of the state. If you have a property that's 10 acres or more, and you want to do commercial development on that property, you probably are going to need to talk to the people who regulate Act 250 and apply it. In smaller towns that don't have zoning and subdivision rules, that is, we call them 1-acre towns. So in very small towns, if they don't have zoning, the people who actually handle zoning zoning falls under Act 250, and the state actually hands out zoning permits for those towns. In those towns, if there's commercial development on 1+ acre of land, then that triggers Act 250. In general, the Act 250 permits are administered by the district environmental commissions, which are, it says NRB, but there's a different name for the agency that's watching out over it now. The DEC's, District Environmental Commissions, there are 9 of them in the state, 5 physical offices around the state. The different districts are based by land areas, you can imagine. So that one district will have a certain area, usually has the same environmental conditions in that district. Each district environmental commission has a district environmental coordinator who is the person who's making decisions on the permits. And that is the person that if you have a project that might trigger Act 250, you're going to want to talk to that person, to the district environmental coordinator for your district. The reason is that if there's some concern that a business or a project needs to have an Act 250 permit, they should get a JO, a jurisdictional opinion. That's something that the district environmental coordinator can issue that looks at a project, looks at the impacts it's going to have on the town, on neighbors, on the environment, and will issue an opinion saying this project requires an Act 250 permit or it doesn't require an Act 250 permit. So sort of a pre-look to see if a permit's required. Definitely recommend that if there's any sort of question. The rest of the bullet points on here I can skip. There's just a process. There's the different ways to handle different projects under Act 250. Neighbors do have power. They get to appeal these permits. They get quite a bit of power in these cases, but they actually have to work harder than they do in town zoning. There's a lot of different criteria: air, water, soil, erosion, town resources, stuff like that. And then there's appeals rights, of course. A neighbor can appeal an Act 250 permit. So that's a layer of concern for a business who has something that they want to get done, and they have to wait until the appeal period is passed. So that's land use in Act 250. That's the one we see almost most often than any other regulatory compliance question. So that's sort of why we spend some time on it. I'll pause and see if there's questions on this topic, though. I have stunned all of you. Land use is complicated, but it's also kind of fun. All right. Data privacy, back to you, Jeannie.
Whoops, sorry, muted. Data privacy. So in this world that we're living in, everything is bits and bytes. And even what we're doing now, we're recording this. My voice will be out there in the cyber wild. I am not concerned about my data privacy violation here, since this is a public facing presentation. However, there are lots of ways I use the internet on a daily basis in which I would be concerned about how businesses are using my data. All right. So we often think of this from a consumer protection perspective. So I'm concerned about what happens to my data. But what if I'm a business? What do I do with that data? How can I keep it safely? Right. So there's a series that cybersecurity experts often use. And these are the steps. I've seen them in all different kinds of ways. We talk about, CIA, which is confidentiality, accessibility, um, and the last one. Oh, yeah. Okay. So we'll just leave the I out right now. So take stock is the first step. Take stock for data privacy basics is when, as a business, you say, what am I holding? And most importantly, why am I holding it? Am I holding it because someday I can imagine a time in which I would like to use this data in the year 2050? Yeah. If that's why you're holding data, don't, right? It creates more liability to you than it would unless you have a very specific purpose for retaining data. Don't retain it. Get rid of it. So take stock of the data you have, think about why you've got it. And then if you don't need it, scale down. Don't keep it, right? Get rid of the data you don't need for business purposes, right? And I am not saying get rid of your tax returns. I am not saying get rid of your accounting data. I am saying if somebody made an inquiry of your website and you say, yeah, we don't do that here, and they put in their name, address, and phone number, delete it. They have no further association with you. There is no reason to save that information, and it just becomes a liability to you, right? So, and there are other circumstances, of course, in which keeping the data is merely invitation for somebody in discovery in a lawsuit to find things about your business that you really didn't want them to know. So, if it seems like you wouldn't want to write it down and put it in a filing cabinet and save it for somebody to find, don't leave it electronically. I mean, that's just silly, right? So be careful about what you save and think about what you save. And if you don't need it, don't keep it, right? Then lock it down. Are you secure? Have you kept your data secure? Sometimes and oftentimes for small businesses, this means hiring a third-party IT expert to come in and do an assessment and help you understand your systems and what it is you're doing. I taught computer science for almost 10 years. I don't do it myself. I have somebody else come in and do it when I was in a business because guess what? I wasn't a security expert. That wasn't my area of expertise. So I didn't have I knew enough to know that I didn't know enough to keep it secure, right? And so that's what I recommend to most businesses. Unless you're in the security business, have somebody come in and take a look at your systems and make sure they are secure. So lock it down. The other piece you can do here, and what businesses often do, particularly for financial transactions, is put it in the hands of a third party. You secure it with a contract and you hand that off to a third party. They indemnify you and hold you harmless if that data is lost, right? So you are handing that data off to a bank that handles it normally and does all of this stuff. So all those credit card transactions are given to a third party vendor in a third party form, and you've signed a contract saying it's not your responsibility, and you want that. So we said scale down, lock it, pitch it. So talked about this. If you don't need it, in the scale down process, get rid of it. Also, future policy. Look at what data you're bringing in and never save it to begin with, right? So pitch the data. Plan ahead. So this is where I do my pitch for what's called an incident response plan. It is not a matter of if your data will be violated in some way or stolen in some way. It's when. All right. And to plan ahead for that, you need to know if your customer's data was stolen, if your partner's data was stolen, if your business data was stolen, who would you have to report to? How would you do that? What would the next steps be for you? If you've thought that through, when it happens, you won't feel panicked about it. You're going to know what to do. You're going to know the next steps to take, and you'll feel confident about the steps you've taken. And you won't make any mistaken gotchas along the way, right? So always a good idea to plan ahead. And then report. In the state of Vermont, the Attorney General's office requires reporting any kind of data protection issue within when you feel that you have lost control of your data and it's out there, you've been hacked, you've got to report it to the Attorney General's office within 48 hours, folks. 48 hours. That's all you got. So oftentimes the folks at the AG's office will be like, yeah, you're part of a large scale attack, and we're not surprised by this, and here's what we expect from you for notification of your customers. Or you will be handled in a larger notification that we are putting out. Sometimes the AG's office will do that. They'll say, hey, there's a scam alert, and we'll put it in our scam alert network. So lots of things can be done here. You really want to take the time to make sure that you've reported it and that you know any expectations of the state of Vermont upon you. All right. Next slide.
All right, so let's jump into some product labeling. This is going to be one of the most common compliance issues for small businesses, especially those that are selling food or packaged goods. Labels aren't just about branding, they're about legal protection. And if something goes wrong, your label will be one of the first things that regulators look at. The FDA is going to be the one that is overseeing food labeling. They're the rule maker, the enforcer, the inspector, and that means if you sell food or drink across state lines or even online, as a small producer, you're going to be under FDA oversight. And every food label has to include the following things: a product name, net quantity, your business name and address, a full ingredient list in order by weight, and any major allergens. And so just a quick example, if you are selling homemade cookies and they contain peanuts, soy, or eggs, those allergens, they need to appear on the label. There's no exceptions for that. If you say something like immune boosting or low sugar, there's going to need to be data to prove that. So it's safer to always describe rather than make claims, and say, made with honey, instead of refined sugar. So just keeping those things in mind about your product, if you're in this area. And when you're selling directly to customer or selling directly to the consumer, make sure you're properly licensed, right? Using safe packaging, and making sure that your employees are properly trained on the labeling and then the way that the food is handled. And remembering that specialty products like teas or herbal tinctures, things of that nature, they may have their own unique labeling requirements and under different agencies. And so just a quick plug, if you have something specific, you can always come to Small Business Legal Clinic and we can dive into those requirements with you. So yeah, just keep those things in mind. And just having a clear and accurate label doesn't meet FDA rules, but it does build consumer trust and protect your business from liability. So there's definitely more that goes into it, but these are the purposes. Let's jump to the next slide. Clothing and children's products. All right, so this is going to fall under the Consumer Product Safety Commission. So that's CPSC. And this agency protects consumers, especially children, from unsafe products. And so a child's product is anything that is going to be made and marketed for kids 12 and under. That includes toys, apparel, furniture, even even home items, things like blankets or wall decor that are like marketed specifically for children. Those things still count. So there's going to be several key safety standards, and there's going to be limits on lead and plastics and coatings. There's small part restrictions for children under 3, flammability standards, testing and certification before selling, and recall reporting requirements if those kind of issues arise. So another example, if you're selling handmade wooden toys or baby clothes on Etsy, something of that nature, you're legally a manufacturer in the eyes of the law. So there's going to be these rules that you have to follow by CPSC testing and labeling requirements as a company. And it's about the product. It's not necessarily about the size of your business, right? So it doesn't matter how much you're making. If you're making this, you need to follow these rules. And for clothing, the standards really focus on flammability and safety. So no drawstrings on kids' hoodies, things of that nature, no loose decorations or beads that like can come off. And there's rules because of small design flaws, right? Or previous accidents that have occurred. To stay compliant, it's really necessary to keep keep your records of testing, of material certifications, different supplier information. And if something does go wrong, you have all that documentation to show that you took reasonable steps, right? So being able to follow the rules, being able to take all of the necessary precautions really does protect you when it comes to liability, but it's also just saying like, hey, I did the right things and being able to put that forward. So whether you're making toys or apparel, safety and record keeping are going to be the best compliance tools you have to back up your business. Let's jump into ADA. Next slide. All right, so ADA website compliance. So this is going to be the Americans with Disabilities Act, as Jeannie already mentioned. It guarantees people with disabilities equal access, right? And so this is going to include your business website. Now I have the statute at the top of the slide, but I'm just going to jump in. So if your business uses a website to sell, schedule, or serve the public, it can be considered part of the place of public accommodation under the ADA. This is going to differ in certain jurisdictions, what exactly a place of public accommodation means. To measure compliance, the courts and the Department of Justice, they rely on WCAG 2.2. And this is going to be specifically for the web content accessibility guidelines. They're built on 4 core ideals. They're listed here: perceivable, operable, understandable, and robust. So what does that mean in plain terms? It's, can the users see or hear your content? Can they navigate a keyboard or a screen reader as operability? For understandable, is your layout clear and concise? And then for robust, does your site work with any assistive technologies. So thinking of those things, what's going on your website? So a quick example, if a customer is using a screen reader, they should be able to navigate the menu and read the product descriptions out loud. And so if you post photos, it needs to include alt text describing what's shown. If you post videos, captions, things of that nature. And it's just the ability for people to access your website, right? So it's the small steps that make a really big difference for the consumer coming from whatever end that they have. And there's also these neat tools from Google Chrome, Lighthouse, and W3C Accessibility Checker to review your website and think about easy fixes. But the sole purpose here is just, allowing people access, and accessibility equals prevention, right? So it protects your customers and keeps your business ahead of legal risk. And let's jump into one more slide about this. Great. Okay. The slide's a little bit small for the eyes, but now ADA compliance, it doesn't apply into every single website or digital system, right? So there can be websites that are purely private. For example, a password protected client portal, something of that nature, an internal employee dashboard. It's not considered a public accommodation under the ADA. So thinking of internal only employee systems that fall under that Title I and not Title III, those are handled through workplace accommodation and not website access laws. So just being able to make those distinctions, this is internal, this is public facing, right? And not every individual condition creates a legal requirement. So for example, there's no specific law that requires your site to adjust for color blindness, right? But using high contrast design, it's still a good idea for business, good business practice, right? But the ADA requires a reasonable accommodation. And as attorneys, I think that is one of our favorite words, reasonable. So reasonable steps that make access possible without an undue burden. And, that could mean several things. So having a phone number or a email for alternative access, alternative texts or images, high contrast fonts, or readable design, and then clear and consistent navigation. So if there's ever a demand letter or a complaint, it's not a reason to panic. It shouldn't be ignored. But starting with like a quick audit of the tools I had previously mentioned, but like Google Chrome Lighthouse, those are ways that you can just quickly audit your website, see some changes that need to be made, and then just getting with an attorney, right? So talking with an attorney who's experienced in this area and showing them, hey, I've made these changes. How can I go about resolving these issues before they escalate? So takeaway here is that ADA compliance is not simply about avoiding lawsuits, but it is about making your business open and accessible. But we do want to give a point to talk about some of the legal defenses as well.
Yeah. So if you are the recipient of a claim or a complaint where somebody is claiming that they went to your website and they could not use it because they were not able to use it, their disability required certain supports and they were not able to do what they needed to on your website. That's what an ADA complaint looks like. Person who is, for example, blind, who tried to purchase something and they could not complete the purchase because they could not access the right tools. So let's start with the fact that ADA complaints are based in legitimate concerns for people who have a disability who want to be able to access a place of public accommodation. However, there has been a pattern in the last year or 2 years, actually, we've heard about it from other service providers of people, and I'm not sure where they're coming from, but probably coordinating an effort to target websites, to find websites that have some sort of a flaw. Maybe there's not enough contrast and it can't be seen by somebody with low sight. there is a rash of lawsuits that are being brought against just everyday small businesses who might have some concern with their website. A disabled person will look at their website, will say, I couldn't do this thing, and then they will file a complaint. So to defend against those, one of the things to know about the ADA is that somebody who is providing a place of public accommodation does not have to provide perfect access for everyone. They can provide reasonable access for most people. And if there's a specific concern raised as to a group of people with a disability not being able to access a particular resource or join something, that particular need can be addressed, but there is a limit on it. It's a reasonable accommodation. The business does not have to spend gobs of money to make everything perfectly accessible. So that's one thing. Another thing is, too, if somebody's been sued for an ADA violation, one way to address it is to consider whether this is going to happen again. So if somebody came to your website, they tried to buy something and they couldn't buy it, and they filed a claim that this is an ADA violation, fix the website, see if there's something that can be done to the website to address the accessibility issue, take steps to come into compliance, right? And then the question becomes in the claim from the customer, okay, we fixed it now. Was there a desire to come back and do this again? Or was just a one-time purchase? There has to be proof that the customer not only could not access the website the first time, but they want to come back and access it again, and that they simply cannot because of the accessibility issue. So it's possible to dismiss some of these cases by saying, this is moot. This is a person who came here once. They don't actually intend to come back, and we fixed it anyways. So basically dealing with the issue to begin with, questioning whether the person who's raising the claim actually has a legitimate claim and is planning to come back, and that they would need to be accommodated. That's how those cases are defended against. But they are very concerning. First thing you got to do is talk to an attorney, because those things move very fast. That's the end of our content, folks. We do have some time for questions. I just want to make sure we leave that open. Thanks, Robin.
Thank you, Nicole and Jeannie and Christina. Nicole, would you mind turning off the recording, and then we can open it up and still keep everything within us chickies?
Sure.
Anybody have any questions?